It is a great honor to be part of the third forum on the developing countries and international law. At the outset, I extend my sincere gratitude to my distinguished colleague Mr. Sin-Min Ma for the invitation. Today I will be speaking on 80 years of the International Court of Justice, bridging regional disparities and narrowing the developing divide. Between May 1947 and July 23, 161 contentious cases and 29 advisory proceedings have been brought before the ICJ. In all, the court has rendered 145 judgments and 28 advisory opinions. However, the volume and nature of cases over time are closely linked to the court's gradual evolution into a truly global court. The period of 46 to 71 witnessed less volume of cases. The situation changed from 76 to 96 with increase in volume of cases post review of the role of the ICJ in 1971, where 26 states predominantly from WIOG and EEG provided views and suggestions concerning the role of the court. This period also marked a growing confidence of the African continent in the mechanism of international justice. Further, the Manila Declaration of 1982 emphasized that states should be fully aware of the role of the International Court of Justice. From 1996 onwards, the steady rise in cases reflected the international community's growing reliance on the peaceful settlement of disputes through judicial means founded in the demonstrated independence and impartiality of the courts and its members. By the 90s, a new trend had emerged in Asia to increasingly resort to international adjudication as a significant means of peacefully settling disputes. The evolving acceptance of ICJ was aptly foreseen by Judge Mohammad Bijawi on the occasion of the United Nations 50th anniversary, when he observed, "The court takes its decisions on the basis of law, following a most meticulous examination of each case without failing to take account of the meta-juridical factors, the expectations of the parties and the imperative of requirements of justice and peace." Thus, many smaller or weaker states have obtained through the court what it would no doubt have been able to secure by other means. The growing recognition of the court's role is further reflected in the 2005 World Summit outcome, where heads of state and government reaffirmed that the important role of the International Court of Justice, the principal judicial organ of the United Nations, in adjudicating disputes among states and the value of its work. As of June 25, approximately 126 states have been involved in contentious proceedings before the court, either as applicant or respondents, with significant states from Asia Pacific and the African group. Another important factor that has advanced the work of the court is the active role of the President of the court in fostering relations with international organizations and subsidiary bodies while steadfastly preserving the court's independence. The President has consistently engaged with key forums such as the Sixth Committee, the General Assembly Plenary, the International Law Commission, as well as regional bodies like ICJO, and has regularly addressed heads of state, government and heads of international organizations. Similarly, the provisionary advisory procedure provides the court with a very real way of participating and contributing to the overall objective of the UN. In addition to offering legal guidance to the requesting bodies, it can play a role in international dispute resolution and prevention and clarification and development of international law. A recent and relevant example is the advisory proceedings on climate change. In this matter, over 100 states and international organizations appeared before the ICJ to present their views on states' obligations concerning climate change and the legal consequences of any breaches pursuant to a request by the General Assembly. In fact, the several states took part in the court's proceedings for the first time in history. I take this opportunity to pay tribute to the past and present members of the International Court of Justice, particularly those hailing from the underdeveloped and developing states. The composition of the bench and representativeness has played a key role in broad acceptance of the court. For instance, one major factor which strengthened the trust of African countries in international legal institutions was the decisions from 1970 to give African countries 3 members on the bench of the court. Africa was therefore better represented at the court. African perspectives on international law could be brought to the court in decisions on cases concerning Africa and international law in general. I take this opportunity to emphasize what Judge Taslim Elias' contribution and emphasis on Africa's participation in the foundation of international law. He emphasized on inter-civilizational participation or a more democratic process of international law making in the process of crafting genuinely universal norms. I fully support this inclusive approach, which I have reiterated in the International Law Commission and commemorative events celebrating 75 years of International Law Commission. It is important to emphasize the dedicated efforts made by members of the court in promoting the wider dissemination of international law across the globe through public lectures, participation in seminars and other academic engagements. These efforts align with the General Assembly Resolution 78/107, which acknowledges the role of states and international organizations in enhancing activities that promote the teaching, study and dissemination of international law, particularly those that benefit individuals from developing countries. Institutions, to name some, such as the American Society of International Law, European Society of International Law, Asian Society of International Law, African Association of International Law, Latin American Society of International Law, International Law Association, Institut de Droit International, Indian Society of International Law, Japanese Society of International Law, Chinese Society of International Law, Xiamen Academy, Korean Society of International Law, Société Française pour le droit international, Australian and New Zealand Society of International Law, the Canadian Council on International Law, Brazilian Society of International Law, Chatham House Center for International Law, National University of Singapore, Hague Academy of International Law, Rhodes Academy of Oceans Law and Policy, UC Academy of the Law of the Sea, the UNCLOS Summer Academy, United Nations Nippon Foundation Fellowships and Alumni Network, Law of the Sea Institute at UC Berkeley, Korea Maritime Institute, Australian National Centre for Ocean Resources and Security and the Max Planck Institute for Comparative Public Law and International Law all play a pivotal role in fostering in international legal scholarships and engaging, promoting the participation of scholars from developing regions and inviting members of the international courts and tribunals, leading academics and practitioners to deliberate on contemporary issues of international law. To pinpoint a trend, as noted by Judge Donoghue, the court's pronouncements on questions of law attract interest beyond the parties to a case. Soon after the court issues a judgment, there may be tweets and blogs that comment on the court's view of the law, followed in time by more detailed scholarly analysis. Today's event coincides with the 35th meeting of the state parties to the United Nations Convention on Law of the Sea. On this occasion, I take the opportunity to reaffirm the significant contribution of the ICJ to the formation and progressive development of the law of the sea. The judgments of the courts in not less than 32 cases have deliberated on UNCLOS provision on the extent of the territorial sea, the delimitation of the territorial sea between neighboring states, the continental shelf, the exclusive economic zone, fisheries, the legal regime of islands and navigational rights. The parties to those cases have included states from all the 5 regional groups. In some instances, all the parties to the case have been parties to the conventions, and its provisions have therefore been applied as a matter of treaty law. In other cases, particular provisions of the convention have been relevant because the court found that they reflected customary international law as it stands today. To summarize some of the cases, beginning with the Corfu Channel case, the court helped shape the principle of the right of innocent passage. In the fisheries case, the court recognized the legitimacy of drawing state baselines in certain coastal contexts. The North Sea continental shelf cases clarified the legal principles governing sovereign rights over the continental shelf and rejected equidistance as a mandatory rule, thus promoting equitable principles. The idea of a single maritime boundary, now frequently adopted by states, can be traced back to the Gulf of Mine case. In the Libya-Malta case, the court affirmed the customary international law status of the exclusive economic zone and emphasized the distance criteria to avoid disproportionate prolongation. In the Jan Mayen case, the court observed that applying the equidistance principle could lead to an equitable result, thereby reinforcing its role as a practical tool for delimitation. In the case concerning maritime delimitation territorial question between Qatar and Bahrain, the court held that the provisions of the UNCLOS relating to the delimitation of the territorial sea Article 15, the EEZ Article 74(1) and the continental shelf Article 83(1) reflect customary international law. Finally, in the maritime delimitation in the Black Sea case, the court elaborated a structured 3-stage approach to delimiting overlapping maritime zones, which has since been widely cited as a standard methodology. This was applied also in the dispute concerning the maritime delimitation in the Indian Ocean, Somalia versus Kenya. On the land and maritime dispute between Equatorial Guinea and Gabon, the recent ruling, the court held that the UNCLOS has the force of law between the parties insofar as it concerns the delimitation of their maritime boundary. However, the principle that the land dominates the sea does not automatically assign coastal states rights to specific maritime areas, reasoning that while the principle may concern the delimitation of the parties' common maritime boundary, it is not itself the source of a right to specific maritime areas. The summary of landmark judgments serves to illustrate the International Court of Justice 80-year legacy in clarifying and developing legal principles, norms under the law of the sea, thereby contributing to legal stability, predictability and the peaceful settlement of maritime disputes. Over the past 80 years, the ICJ has steadily gained global recognition as the principal judicial organ of the UN, reinforcing the rule of international law affairs in international affairs. More than 90% of the court judgments are complied with, a testament to the trust that states place in its impartiality and authority. One of the court's most remarkable achievement is its ability to transcend traditional divides, whether geopolitical, economic or historical. At the International Court of Justice, the dichotomies of large or small state, powerful or weak state or developed or developing country are rendered immaterial. Regardless of a state's size, influence or economic status, all parties stand equal before the court, that is, equality of arms. The court has played a central role in bridging regional disparities in access to international justice. This inclusivity and legal impartiality have made the ICJ a cornerstone of the international legal order and a symbol of the universality of international law. This jurisprudential contribution in achieving the maintenance of international peace and security, and thus fulfilling one of the fundamental objects of the UN Charter, remains a matter of deep appreciation and satisfaction to the international community as a whole. In closing, I express my deep appreciation once again to my distinguished colleague Dr. Ma, the Government of People's Republic of China for organizing this event, as the world anxiously look upon the UN and the court, its principal judicial organ, in its search for a just international law based order. Thank you.